like problem. I don't like all the group teaching thing.
No, I don't
I'm
think
not
that
into
either. Nobody, everybody who I've ever talked to, nobody likes it.
I'm not a fan of that.
Doing well today, Francis. How are you?
And you know what would kill me? I would be in a group, you know how it's by random number? I'd be the only one who read and briefed the damn case.
Right.
Yeah, that's what I thought.
I was like, why is it I'm the only one reading it? Here's my brief. You know?
Yeah, I find that happens a lot, and it's like no matter if you count off by 4s, 5s, or 8s, and I'm like something, I'm like, oh, come on.
It's like, come on, somebody else, you know?
Yeah, I agree.
Invariably brief the case.
I think I lucked out once where like everybody in the class, everybody in our group had read it.
And then they don't have canned briefs, they're all the same.
Okay, I hate to interrupt your conversation, but we have to finish our cases on insurance issues tonight. And we had, when we left here, we were examining the Timpson versus Transamerica case, which also got us into the notion of under what circumstances an employer is responsible for the acts of their employee. And there was some concern about whether the sports writer even belonged in the locker room, but since others were provided that access, she wants to do that work. She had little choice, I think. But tell me how Timpson isn't within the scope of his employment, but Ross Grimsley, when he throws the baseball at a heckler, and he's a professional pitcher who can throw the baseball with some force, that he is considered to be within the scope of his employment when he clearly, I mean, that's a criminal activity as well.
He's got a better lawyer.
I think there's a big difference there, because like he's trying to pitch, he's in the scope of his employment, he's actually pitching, he's actually doing this thing. The guys there distracting him, he takes the ball and he whacks him. You know what I mean? Versus this whole, I mean, that's pretty much what happened.
Yeah, I agree. That's what happened. How does that make it the scope, of course, of his duties? I mean, his duties aren't to throw the ball at the face of the heckler.
Yeah, I mean there's a good argument for that too. But I would have thrown the ball at the heckler too.
I know. But what we would do doesn't mean that the law supports what we would do. You know, the same thing as when we left that discussion is you've ever seen the image of I think it was Terry O'Reilly and Mike Milbury both going over the boards,
the whole line,
and hitting the Rangers fans is my recollection. So no problem with that. With the bottom of the shoe, I mean, those are likely to be acts within the scope of employment. With this guy, when he is talking to a reporter, which he's required to do, goes beyond what he should be doing. For instance,
I think the court.
And true, he wasn't necessarily the principal culprit. Go ahead.
I think in the absence of the intentional acts exclusion, I think the court could have gone the other way in this. I think that which I don't know if it existed in the baseball pitcher's case, but Timpson's contract, the insurance company, the insurance policy specifically excluded intentional acts, whether baseball, football, throwing yourself into the crowd and injuring people. I think any intentional act would have been.
Well, but the court also in Timpson went, I think, at some length to try and make the determination whether he was even in the scope of employment, and said it fails the first part of the test. He wasn't acting even in part out of an interest to serve the master. Creating bad public relations isn't what he's paid to do. He's supposed to create good relations with the press. And so that little hairline distinction, well, Grimsley at least was paid to throw a baseball. Even if he threw it at the wrong person, that's okay.
Were they using the same test in both?
Oh, you would? Well, the test is usually pretty much standard with respect to whether an agent is within the scope of his employment.
I'm just thinking, you know, the baseball one, if you're going to make even an argument on like the third part, was it motivated in part, you know, in some parts the purpose of the employer? You know, sitting there getting heckled while he's pitching. His purpose serving the employer is to pitch well. You got some guy heckling you, distracting you. Now you're throwing balls instead of strikes. So you wing a strike right at the guy's head. get rid of the heckler, and now you can pitch better. I mean, it's an argument, isn't it?
Well, it's not just an argument.
And-
The First
but in
Circuit
but in
accepted
Kinzer,
your
he's
logic.
not- you know, he's not being heckled, he's not on the field playing ball, he's not even being interviewed. He's just coming up to her and sexually harassing her.
Well, but you would know back then that the male athletes felt that the women didn't belong in the locker room. There's some
Oh, yeah, I
female
remember
athletes that
it.
think they, even in 2011,
but-
don't belong in the locker room.
But, you know, I
Strongly
mean,
believe.
feeling like they don't belong there and conducting yourself in a manner that can, you know, bring, you know, that's illegal are two different things.
Well,
You know.
Grimsley,
Well,
when he
same-
throws
yeah,
a baseball at some little kid heckling him, is going to bring.
Oh, now is it a little kid?
I don't know. It makes it worse.
So, you know, you're outside the baseball field, and you're just walking around and you wing a ball at somebody, sure. Yeah, I mean, I understand what you're saying, but we're trying to fit it into this test. You know.
And so that little sliver of that he's at least paid to pitch a baseball, and it's not the same as saying, well, he's paid at least in part to interact with the press, not this type of interaction.
Well, I'd also argue too, I mean, it is a stronger case within the authorized time and space limits because he's actually out in the field as opposed to being in the locker room. I think that provides a stronger argument for my number two, satisfying that standpoint.
Well,
I mean,
what is
look,
it?
when a guy when some of these, you know, these idiots run out onto the field, players can run up and level them if they want to. It's the same thing. Well, it's not exactly the same, but it's, you know, I'd use that as something to argue. You know, you're not going to get in trouble for that.
Well, then help me under this, and I guess you're comfortable with Grimsley. Help me to explain that if I wanted to sue an employer for the sexual harassment acts of their supervisor, that isn't going to pass the Wang test either, is it? So, at least under respondeat superior, you have no ability to sue the employer for the sexual harassment of their supervisors.
No, I disagree with that. I think you could get them on a failure to train and supervise.
Okay, but I'm saying, but it's not on respondeat superior. You're alleging a different theory, and that's what I wanted to make sure that we're somewhat in agreement, is that the employer's gonna have to do more, you're gonna have to allege more than simply he was acting in the scope of his employment, and while acting as the supervisor, he harassed the subordinate, therefore Home Depot, BJ's, whoever is liable for those acts, because it's not really going to pass the Wang test. How is that motivated in part by a desire to serve the employer? I mean, it's motivated in part by your personal desires, right? I mean, if the Wang test is what it is, and it is, as it says here, Francis says, well, maybe I can get them on the failure to train properly, failure to supervise, or creating a hostile workplace environment, but I can't get them really on respondeat superior because it's not going to satisfy the Wang test. Do you all agree?
I don't think the sexual harassment is motivated, I don't think the motivation is to serve the employer. So I mean.
Be a
so
tough
that
sell,
would-
wouldn't it?
You'd be failing the one test there.
Right? The conduct is the kind he's employed to perform. You're not paid to, well, I don't pay you to grab ass with the employees.
Yeah. Number two, I have a
So it
problem.
fails on 1 and 3.
Well, it might be authorized time and space,
Yeah,
but it happens in the workplace.
But it wasn't incidental to or in the same general nature of the responsibility of the agent as authorized to perform. You know, he wasn't authorized to, you know, make lewd and lascivious remarks and gestures to a reporter in the locker room. I mean, I don't consider that within the scope of his employment.
Well, but let me ask you about that, because I wonder, and I don't know whether it was Britt's point tangentially or not otherwise, but there is sort of a expectation that men in a locker room are probably likely to be crude and derisive, certainly with each other. Maybe women do the same thing in the locker room. But you do right, you do interact with each other differently. I don't know about, no, I'm not saying it this way. I'm just saying that there is there's certainly a level of vulgarity and crudeness that one would expect would be pretty commonplace in a football player's locker room. No?
Yeah.
I say, no.
Maybe hockey players,
Oh, definitely.
females as well.
Yeah. Maybe
So-
not like comparable, but I still think that there's private, like, I think it's more of a private place than people
Right.
from the outside think. I mean, I feel like if you ask some people, they think that the reporter should be able to go right in there, right after the game, they should be in there before the game, which I think is completely wrong. So,
And if anything, they should go after the owners who are allowing the press in there. They have the liability.
Excellent point.
Because I think it's the people that are allowing them to come in.
yeah.
I mean.
But
they
so
don't
what's
know
the
if
theory
they're-
of liability for the Patriots at that point? Some sort of negligent supervision of their employees? Well, and by the right, in some of that, there was a Patriot employee, manager, supervisor of some sort, standing right there when all of this was taking place. No one said, hey, knock it off.
Yeah, knowingly exposing the reporter to a hazardous, potentially discriminatory, outrageous environment. Yeah, they knew what was going on in the locker room.
So they may have some liability on their own, just like you suggested for the sexual harassment, but it's not going to be respondeat superior.
No.
He's outside the scope of his employment.
Right.
Maybe they should have done other things, especially with the supervisor there, and they didn't.
If you think your employees are going to act like 8th graders around adults, then you have to protect the adults.
But so then, if one of these days someone comes to you with a sexual harassment claim, what we know, we start with the notion is, well, it's not a respondeat superior against the employer. I'm going to have to see what else the employer did that was improper. I mean, if they have regular trainings, if this is the first complaint, if they
Their previous knowledge of the environment.
no,
and
but
yet
suppose this is the first time any complaint has come to their attention. The environment hasn't been problematic. Then you have a claim in all likelihood against the supervisor, but not the people that have departments. Is that right?
Yeah.
Well, that's the whole notion of the frolic, right? If the employee's on a frolic, he's on his own. And you might want to get Home Depot or Fidelity to pick up the tab on this sexual harassment claim. But what if they've done everything right and the employee is just sort of a rogue acting outside the scope of his employment? Well, you're on your own, aren't you?
But once it happens the first time, if they've gone to human resources and they've complained, what actions did the company take to, did they just slap them on the hand? Or did they actually put something in place to make sure that didn't,
Well,
take them out of that position?
That's the next phase, right? That's the next phase we have to look at. Does the employer do something to create a hostile and oppressive environment? Have they failed to supervise this person properly? I mean, it's a different argument, but I don't think you're making the argument on respondeat superior for the most part, because it's not going to satisfy your weighing test. How do you suggest that that is in part motivated to serve the master, or that it's the type of work that the person is paid to do? Because no one pays you to do that, as a general, not lawfully. 176D, it makes reference at the end of the case. Because what he's looking for here is for the insurance carrier to pick up the cost of his defense. The case at this point is settled. That he lost that by way of summary judgment under both 93A and 176D. But the fact is, this isn't an unfair claims in settlement practices case. The fact is that A, they didn't see owing any liability to him on this, and more so, they did, at least in part, work with him under a reservation of rights. And the fact is that he's out of money. Well, that's just too bad, because this isn't likely going to be a claim that they have to pick up on behalf of the Patriots anyway, because he's acting outside the scope of his employment at this point. I think it's a good case, and I think it raises a bunch of those issues about agency and the like, and asks you to start to try and figure out where someone's within and where someone's without. And the scope of their employment. I think that Grimsley and Timson, I think you're probably making the right distinction. But geez, that sounds like a razor-thin line there.
But they're different?
Yes. You think that's
No, I think they're both within the scope of.
Oh, you think Timson is,
Yeah,
but he's not.
I got that. But I think he should be considered. But I feel like.
What's your response, Brett, to this would be criminal activity done anywhere else, and he clearly can't be thinking, as his friends are waving their stuff in front of the reporter, that this is going to be good for the Patriots football organization.
Yeah, but the fact that the owners or whoever it is set up the media day in the locker room, in my mind, like they had knowledge that this could play out like that. First of all, there was no prerequisite that any of the players had to be dressed before the media came in. So,
right.
I mean, so now you're saying they're allowed to not have clothes on. So there's your first, like, in my mind, if they would have set up the parameters, listen, media, they get 7 minutes, they can come in, they can talk to so-and-so, you guys have to be dressed, the rest of you can't be in here until then I would say fine. But a locker room is like a private place. So I would say, just by him showing up,
it should be a private place, but it's not.
Just by him showing up, he met the duties of being within the scope of the employment. The way he acted, I mean, he could have, what if it wasn't his actions, but he said something? What then? That's different? I mean.
You don't buy in the team unity though at all? Because I mean, isn't that, what is he supposed to do?
Not act illegally.
Grimsley acted illegally and he was covered?
That to me is way more serious. He chucked the baser. You know how hard those guys throw that thing? Like, that, to me, you could have seriously hurt someone.
This is offensive.
It's offensive, but in no way was, like, in my mind, and I'm not trying to downplay it, but in my mind, she wasn't injured, like physically injured in any way. Like,
She signed up for it.
There was
She
no
accepted
attempt
it.
to, like, hurt,
Yeah,
like.
Grimsley was bad
We
law.
have Jackie McMullen here
Well, then
last
under
year.
that theory, though, the guy in the stands signed up for it too.
To get chucked baseballs
He's
at?
Heckling the guy. He's bringing it.
Yeah, but
She
heckling
just
is
she
a
walked
normal
into
part
an
of the
environment.
It's not like there was one guy in the crowd heckling him. You get heckled every game. You should know that.
This was the one that
What,
you
you're gonna
heard.
peg all of them? Sure.
Honestly,
And they should know that.
And still be in the scope of his employment. And I bet that silenced that section.
Totally cut you off.
What about what is he supposed to do? His colleagues are all doing this activity. I just joined in for team unity.
Yeah, I'll jump off the bridge again too.
Well, I know, and and that's Francis's point the other day, and I do sometimes think of this, is, well, you want us to cover this, I mean, would you be able to go home and tell your mother what you did under these circumstances? Because I think that would be, because what your line is one of my mother's lines. I mean, if you think what you did was right, such that it should be covered, do you really think it was so right that it should be covered under the insurance policy? Or were you wrong, and lawfully that you're going to now have to pay the price for it? I have a hard time distinguishing significantly Grimsley from this. Because I do think, I think if I apply the test strictly, I think a credible argument can be made that the conduct is the kind he's employed to perform. He is employed to perform activities interacting with the press. And I'll take Britt's point a little further. I actually don't like doing it. I would prefer, if I were in the locker room, I would prefer that I get my personal space, that I'd be allowed to be able to take my shower without people watching me walk around the locker room naked, and that I get dressed, and then at some point I can go out to the press room, and I'll hang around for 10 minutes and let whoever has questions ask questions, but then I get to go, because that seems like a better way to do it. So I'll do it if you make me, but don't expect me to do it well. I'm not so sure that's unfair to say that I'm going to, and especially where I really do think it takes a little bit of a screw loose to play football. And so I think you're saying, I'm going to put you in these difficult positions that you may not know how to deal with as well, but deal with them appropriately at all times. I think as you guys have said, you said that's a risk that the employer may decide to take. I'm not so sure that that's a wise risk to take. Authorized time and space, I have no problem with the locker room being authorized time and space. I understand the argument about the field, but if they get to come in to interact with me because it helps market the business for the Patriots or any other NFL franchise, time and space, that's where part of my time and space is spent, is within the locker room, getting ready, and then at the end of the day, leaving there. His problem is 3.
Says is motivated at least in part by the purpose to serve the employer. At least in part, him showing up is at least in part serving the employer.
But it's actions.
Yeah,
It's
he
not-
physically stepped into the room
But
and
what
he was in part.
what
at
he
that
was
point.
actually doing to her, is that in part served by motivation to serve his employer?
He didn't do
Not
anything
just
to her.
being.
Yeah.
He was laughing and shouting encouraging words to his male teammates, all of whom were allegedly sexually harassing the reporter, which he sees it as promoting team unity. Therefore, the team will play better.
Agreed.
No, but that's his argument.
If he wants the big guys in the front to block him, he's gonna be.
Fair enough. I mean, that
Put
is,
your life in your hands.
at least is his part.
I think it's a close call. You made a compelling argument. I think Grimsley is the bad law here.
Well, Grimsley bothers me. I mean, you
That's assault.
deliberately
Brett
take
said-
and
Brett
throw
said-
the baseball,
Like Britt said, that's the assault and battery with a deadly weapon. He should have been arrested.
but he is paid to pitch. Clearly paid to pitch.
Yeah, but
No,
not
I-
into the stands.
Well, you know what? Let me ask you that though, because I thought about that, not at people, but, and I argue with this about Professor Malaguti. In baseball, it is okay to take that ball by a professional athlete, throw the ball at someone else's head
But they know that could happen.
In the game?
The batter?
in the game.
Wait, if fan?
No, at the bat.
Oh, yeah, but the batter knows. The
Well,
batter,
that's like in
no,
hockey with
no, that's
fighting. I mean,
true.
at some point, right, look.
If he's gonna crowd
I'm
in, you gotta
Fighting
go
is
like-
one thing.
No, but aren't
Throwing
they
a
starting-
baseball at my head, I'm having this discussion with him. I should be able to take my bat with me and beat you with that bat now.
Then.
No, but then I'm the one that would get in trouble. You can throw a baseball at my head. I can't. You throw a baseball at my head. I'm supposed to put my bat down and then charge you from 90 feet, 60 feet away, and have all your friends stop me before I get there. I should be able to take my bat with me. No, really. No, I'm serious, right? No, but how is that not? You've thrown it. You've taken in the real world. If someone attacks you with a deadly weapon, you have the right to defend yourself with light force.
Yeah, but
A
there's
baseball thrown at 90 miles an hour is a deadly weapon.
No, once the ball
So
passes
you
you,
throw
the
it
assault
back.
is over. You can't conduct postscript defense.
Well, I
I
mean,
don't think it would happen again. I
there's
think-
a certain assumption of risk that a baseball player takes when he steps to the plate. You know that you're having a baseball thrown at you anywhere from 90 to 100 miles an hour, and if you piss off the wrong guy, then that pitcher is going to take a pitch at you. It's like a boxer stepping in the ring.
But the
You know that you're
retribution
gonna
for that is all I
get
can do is punch you or kick you. I can't hit you with an
Well,
implement that I really
no,
have a
you
chance
can't.
of.
The pitcher gets a couple warnings, he gets tossed out. If you charge the pitcher, if you're not thrown out, you will if you sneeze crooked in the rest of the game. There's a system built into the game to regulate that. There is not an assumption of risk as a fan that you're going to get a ball thrown at you no matter what you say. The proper course of action should have been to alert security and have him removed from the park. The pitcher is paid to pitch, but not paid to take out a fan.
But that's not consistent with the First Circuit's decision.
Well, yeah.
Right.
So the law is obviously different from my own opinion, but then in the sexual harassment case.
So wait a minute though, so just to take your logic then, when Terry O'Reilly and Mike Milbury go into the stands to beat the Rangers fans with their shoes, outside the scope of employment, or no, it's hockey now?
No,
And they're all
way outside.
from Canada.
That's outside the Bruins Canadians. That's a great rivalry, but no, I don't expect them to jump out of the ring and start beating each other's
They have
fans
like
up.
skates on, they're like climbing in the stands.
So that's
if
not
they get
covered?
over the 10-foot
No.
wall, then sure.
No. So the players will be responsible for the Bruins on, even though fighting promotes their game.
That's, I don't agree with
Well,
that either.
What?
Only among
The
the younger
fighting
crowd
part.
are usually bullshits. Older folks don't like the fights.
Is that what it says? Okay. We gotta move on, but I think it's an interesting case to start to think about, and I think you can apply it to other situations where you start to think about, well, under what circumstances is the employer responsible for the acts of their agent? Oh, yeah, go ahead, I'm sorry.
I just have a quick question.
No, make it quick.
Why respondeat superior wouldn't work now? Because it says right here, James Oldham, a member of management personnel for Patriots, was present and made no effort. So he's a member of management, so he's, by agency theory, he's an authorized agent of the Patriots, and his silence might be an admission of consent. Could you go on that theory?
Well, let's take a look at his potential liability, because he might be, and then I think that's the
I mean, you
Francis'
could
ability to
say
supervise.
Yeah.
But Timpson is outside the scope of his employment. Let's see if the supervisor is.
No, I'm not talking about the supervisor.
No,
I'm
no,
talking
but the
about
supervisor for the
company.
failure to stop this activity now, right? So whether then the Patriots are responsible for his acts or inactions, okay? Is that what he's supposed to do there? Is supervise how the players interact with the press?
Somebody has to.
Well, you wonder if he's on the marketing and PR staff, that's one thing. If he's, in charge of laundry,
Right.
then he might be outside of one. Two, it occurs substantially within authorized time. I think that would be easily satisfied. It is motivated, at least in part, by a purpose to serve the employer. Well, what we're really trying to say is his inactivity now somehow is going to satisfy this test. I think your hope is, and I think your case is that supervisor's responsibility in part was to try and make sure things didn't get out of hand.
Because why
Having
was he
failed to
there?
stop it, now the Patriots are
Why
alive.
was he there? He was the supervisor. He wasn't
Well, they
changing his
they said
role.
he was part of management.
Right.
But we don't know what his role was with management, right? I mean, they may have 50 different people that have management responsibilities.
Personnel, so.
Well, see, again, I think personnel is closer, that he should be,
In charge of the people, so he's in charge of the
Whoa,
people.
well, but the fact is, again, a major corporation might have 20 people in personnel, so we don't know whether he had supervisory capacities over these employees in this way, and that's all. I think they are liable even for the failure to supervise whether this person was supposed to be the supervisor for this activity or not. I actually agree with Britt, is putting, the little bomb together with all the combustible materials and then not being there to supervise that it goes smoothly, especially back during the time period when this case came out. Because when this case came out, this was all a relatively new issue. To not have steps in place so that things would go more smoothly, they're probably liable in and of themselves. The case ultimately settled. When Jackie McMullen was here last year, she's a sports writer, had been for the Boston Globe and Sports Illustrated and the like. She thought, and she said she knew Lisa well because I asked her about this case, but she thought that it had in part been mishandled on both sides. She thought there were ways to raise this that this could have been taken care of. And she also said that this type of activity, this is an extreme, but you had to expect that you were not really welcome there. And to the extent you reacted, you could make it worse. And by the way, it isn't just female sports writers. If you remember, shortly after this, there was the incident in the Patriots locker room where Raymond Claiborne, their cornerback, punched out Will McDonough, who was a sports writer for the Globe for many years. So there's always some level of tension, and has been, between the players and the press. The question then becomes, well, to what extent is the company that employs those players responsible for it? And I think it's depending on what it is, it's not likely to be within the scope of their employment, within the scope of their duties, as it says. I think it's an interesting case. Let's take a look, and that's the start of 176D. Let's take a look at Brantley versus U.S. Fidelity and Guarantee. Driver and passenger brought an action in state court against the insurer of the other driver's employer alleging violation of Mass Consumer Protection Act, Unfair Claims Practices Act. There was removed to federal court where it was heard, and the district court moved for summary judgment. Judge Mazzone said that the insurer's failure to respond for nearly 2 years to injured claimants' initial notice of their claims against insurer did not violate the Unfair Claims Act, but their failure to respond to the more detailed set did, and that damages therefore had to be doubled. As a general matter, 176D, Insurance Practices Act, regulates activities between the policyholder and the insurance company. What's interesting about this case, and this is why I had to read it, is that there aren't a lot of cases where the injured person has the ability to try and argue that the tortfeasor's insurance carrier should have made a more reasonable offer of settlement and should have done it earlier, and therefore they've created liability under 176D. So I wanted you to see the case as it laid out. And I think there's a couple of interesting things about it. It also is a summary judgment case, and we looked at that the other day. But if you look at the start of the discussion, it says 176D specifically describes some of these things as unfair practices. Failing to acknowledge and act reasonably promptly upon communications with respect to claims arising under insurance policies. So what that part of it means is they have an obligation to communicate relatively reasonably with you when they receive correspondence. F, failing to effectuate prompt, fair, and equitable settlements of claims in which liability has become reasonably clear. And that's a big issue, but it's contingent upon liability becoming reasonably clear. What that means is that once there is some basis to say the likelihood is we have liability here, they're supposed to, on behalf of their insured, try to resolve that claim within the policy limits so that the insured is not exposed to incredibly large judgments or judgments in excess of the policy. Which, let me just back up and explain that quickly, although I think most of you probably understand. If you guys have a motor vehicle policy, we'll just call it, you've got 50/100,000 limits on your motor vehicle. You run someone over. What 50/100 means is 50 for each person injured, a maximum of 100,000 per crash. If you've seriously injured someone, then the likelihood is the $50,000 is not likely to be enough to compensate that person for their losses. But the insurance company is only obligated to pay out $50,000 for that person. And there's a real tension that comes into play there because they don't even want to pay out the 50 for the most part. They would rather defend that case in some instances so that we have to pay the cost to defend, but we have to defend you anyway under the policy, which is one of the other things they must do. And so if we've got a chance at a no liability verdict, we might as well try that case as opposed to settling for 50. The insured, on the other hand, has already paid the premiums. I don't care what you pay up to the policy limits because it doesn't cost me a dime. And for the most part, except for the next case, that is the way it is. And so there's a tension there between the insurance carrier wanting to keep their money and their obligation to the insured. Suppose you have a big policy. Suppose you have a $1 million, $2 million policy. Relatively modest accident, but they want 250 grand. Pay them the 250. As far as you're concerned, because it doesn't cost me a dime, but the insurance company is not going to pay out $250,000 simply because you have a $1 million policy, especially if they think they might be able to beat it on liability, or they think you may not be able to establish a claim worth $250,000 but something less. And so there's a tension there between their obligation to the insured and what they, as a business practice, want to do. 176D regulates that. And your obligation oftentimes in these cases as the attorney is to make sure that you force the insurance carrier, if you're the private attorney representing the insured, to force them to honor their obligation under 176D. Because remember the other part of this. So your client has been in an auto accident. You're their family lawyer. Under the terms of the insurance policy, the insurance company will provide them counsel. They will provide them a lawyer to defend this case. However, their liability is only up to the policy limits. If you've got, we'll go back to the $50,000, $100,000 policy. The likelihood is, if there is going to be liability, that judgment may well come in well in excess of $50,000. If it comes in at $500,000, say, the insurance company will write a check for $50,000. And you're writing a check for $450,000, or you're potentially losing your house. And so that's why even when the insurance company has an attorney, as they are required to do under the policy to represent you, your clients should also have separate counsel to push the insurance company and make sure they're doing the right thing. Because, again, we want them to settle within policy limits so your clients aren't exposed. What happens in this case is that the attorney, and I used to actually try a lot of cases with this guy when I first became a lawyer, and his original demand was for, how much was it? $900,000. Yeah, 1.04, right? North of 1.04. And ultimately that claim was resolved for $84,000, right? $84,000. And somewhere when he made his original demand, and I could see this happening, they said, this guy's out of his mind. And they didn't, and I could see him making that demand. And they said, they didn't do anything. Somehow it seemed to get lost. But at the end of the day, he ends up settling for $84,000, and it was much, much later. And then sues the insurance carrier for failing to respond timely to his demand and settle promptly once liability became reasonably clear. And Bramley's $1 million demand seems to say to me that they weren't being serious about resolving it either. And there doesn't appear to be a good explanation as to why there was no follow-up to that initial demand. Hans was deposed, and he said he had no idea why his office didn't follow up on the initial communication. But one thing he said that I thought was interesting is he says that, well, I have no obligation as the plaintiff's lawyer to make a reasonable initial demand. Regardless of what I do, though, the insurance carrier, 176D, regulates them, and they have an obligation to be reasonable nonetheless. Is he right?
Correct.
He is. He is, right?
He is correct. Under the rules.
Kind of bold to say it, though. No. I don't have to be reasonable at all. 176D regulates their activity. So I could demand of you to give me $2 million as the insurance carrier. You still have to act like that's a legitimate request for, because really he ends up taking less than 10 cents on the money. So I guess there's no requirement that you act reasonably at all in making the demand. Certainly not to have legal ramifications to it. That, y'all comfortable with that? Because it doesn't sound like he acted quite that fairly here, do you think? And by the way, you don't have to, I used to try cases against him. He taught me more lessons than a lot, but, you know, and not in a good way. I mean, you know, he's in a wheelchair, always had been. But if you thought that he was disabled as a result of that wheelchair, you were going to be sadly mistaken. He was very, very, very capable lawyer, and he'd use it. He would often use it. And you know, he was very, very clever, very, very clever lawyer. So does that seem appropriate to you? Because now what he's doing on the back end here is he's going to tag the insurance company with double damages because of their failure to treat him like he is, like, treat him seriously, but did he really treat his own claim seriously at the outset?
I think as long as you know the insurance company is, has to respond. I mean, I agree with them, they have to respond. I mean, they can't be, they can't just be lackadaisical about their response. They need to respond. And yeah, I mean, I don't fault him for, asking for what he asked for. No. I think, for example, consider this. In these cases, it could potentially be that you may go in with what you may want to think is a reasonable demand, only to find out at some later date there is some long-term consequence that you never thought about. And if when you do settle, then your clients come after you.
Yeah, Franklin's making the same argument I was thinking about a moment ago, which is the complexion of the claim changes. And the perception of what the value of the claim is may be completely different. And the insurance company has a responsibility. When they're licensed and allowed to sell these policies to the general public, they are agreeing to comply with these rules. And they need to allow themselves to be blind to the demand and evaluate the case based on its merits, not on what the demand is, not be offended by the demand.
And you don't have any obligation, ethically or otherwise, to sort of put forward a good faith demand. Because this demand can't be really advanced in good faith. If you think he ends up taking less than 10 cents on the buck. I mean,
Well, maybe he thought the claim was worth that originally. He might have thought it was worth something. A bit close to that.
Fidelity's not being gigged here for responding with a lowball response. They're being gigged for not responding at all.
Yeah.
So it's a timeliness issue, not the amount that's.
Well, and that's a fair point, and it's even, I'm not so sure they're even getting killed on the first failure to respond, because the judge says it's the second set, when it's more detailed here, that they still sort of falls through the cracks. And I want to make a point to that for you guys to really think about. It says, the demand letters dated November 10th and December 8th detailed the plaintiff's injuries, included copies of medical bills and relevant police reports, indicated estimate settlement values, and discussed pertinent case law, and unambiguously left the ball in Fidelity's court. That's a good demand, okay? And by that, what I mean is, it's not just, give me $1 million. If you really want them to sit down and take it seriously, then a good demand under those circumstances really does just what this does. It gives the supporting evidence, it establishes the damages in reasonable detail. I'm going to give you a demand letter at some point so you can take a look at it. That it isn't just a short paragraph or two saying I want $1 million. It's that someone can look at it and see that there's some concrete basis for how you've gotten where you've gotten. If you want them to take you seriously, then in part you have to take it seriously and put forward that information, so that when someone looks at it, they say, well, this is well thought out. This is not, I still may not agree with the number, but I do understand how you got there. Sometimes people don't want to do that because then they're going to start to pick apart. So you can't get this, you can't get that. But, well, if you got an argument or case law that supports that, then you can explain why. But it begins a serious discussion earlier, hopefully.
No, I was just going to say, but then isn't that justification that his demand was reasonable?
Well, I think, I don't know whether the second one, it says it's reasonable, at least says that it wasn't just pulled out of the air, that there is some support for it, some thought. Huh?
It was documented.
Well, there's document that supports it, and that's what you should do. And the fact is that you are more likely to, or should be more likely to get someone to listen to it and really take a hard look at it. And maybe we're going to disagree that. Well, you're not going to get, $50,000 for scarring. Well, how much will we get? What are we looking at? I'm not going to take less than 25. Well, maybe now we're already narrowing our ranges down so that we may still be far apart, but the fact is we're having a serious discussion about how those numbers are arrived at, and that's never a bad thing. I've proceeded with cases where you really don't know what the hell their position is. I know what I want, I know what I think it's worth, and my demand is not as high as Hans's, but it's higher than what I'm ultimately going to be prepared to take. But a lot of times you don't know till really late in the day, well, you know, are we $700,000 apart, or are we 50,000 apart? Because if we're 50,000 apart, that's money we can deal with, and you don't always know. So the detailed demand at least helps start trying to figure out what people are. You're likely still going to get relatively lowballed at the outset, but not always. There are times where you make a good demand, you really explain it, and for whatever various reasons, maybe they don't want you to file that suit. I find a lot of times with the sexual harassment and the discrimination claims, a good demand, that may mean we can do something sooner rather than later, because unfortunately sometimes once those are filed, people's positions harden, and now they have a feeling, like in the next case, that they need to be exonerated, and that may never happen. But there's a feeling where you actually have a little more leverage sometimes before it's filed, because we can agree to keep it all private, and no one ever has to need to know any of it. And maybe the next plaintiffs, as you said in the last case, don't get to have access to that materials and use it as well. So
I think in defense of Brantley's counsel's initial demand, you know, pain and suffering is very difficult to quantify. And when you're a plaintiff's attorney and you've got everything on the line and you're on a contingent fee agreement, who can blame you for swinging for the fence? It's your paycheck at the end of the week. And
but here's my problem with that. But you weren't even in the same ballpark. If you're going to end up taking 84 grand on it, your initial demand is grossly excessive, isn't it? And I'm a plaintiff's lawyer. I just think, and I agree with you, because you know, one rule of thumb is I can't go back. I can't go up. Right? If I start low, I can't go higher than that as a general matter. So whatever I start with, the number starts coming down. And so he starts.
Something dramatic could have happened in the case. Maybe his
not likely.
Maybe his star witness
not likely.
Suddenly.
No, not likely. I think he said. I think his deposition says it. Because he would say that. That's what he would have said if that actually happened. Instead, what he says is, and I can see him saying, I have no obligation to be reasonable. That's what he said, right? He used to tell me cases said something that absolutely didn't say what he said. And I was what, 25, 26. I go back, looked all through it, read it like 2, 3, 4 times. I said, that's not what it says. Mike, read it again. You know, that's what I told Mike. Mike, you got it wrong. I said, no, I'm going to try this case then. He said, no. You're making a mistake, Mike. What the hell? You're 26, 27. You go back and look at it again. I said, no, I'm right. So we tried it. And you know, so he's always gaming. That's part of what he does. You might see him next week. He's usually at the ATLA, usually one of the judges. Good guy, liked him. But you know, when it came time to write the agreement on the cases you try for a day or two and going to settle, you know, he doesn't even say, Mike, you write it. My hands are killing me from the chair. You know, what's he up to now? You know, so now it's in my hand. You know, there's a scrivener's error. It's on me, not him. No, really, he's a very good lawyer, very skilled.
I like him already.
Well, he taught me a lot. And he was very skilled and very good. He was actually very nice. You know, listen, with a lot of lawyers, you have to be, especially early on, because I think some you'll know they're gonna bust them on you because they can, because they knew. Others will try to ingratiate themselves, but they may be the wolf in sheep's clothing, because they're going to take advantage too. So some of you have your guards up, and others you don't. You got to be careful, and you got to dot your I's and cross your T's.
I was more surprised the judge didn't assess triple damages. I mean, the judge is saying, hey, it was a callous, intentional in the extreme. You know, and I looked at it and I go like, what the hell is this? You know, this is crazy. You know, how could you have conduct that is callous, intentional in the extreme?
Yeah, but did you read the end of it? Where did he say?
Yeah, well, he was talking about that.
The plaintiff's case was settled for less than 1/10 of the demand on the courthouse steps, and he admonished plaintiff's counsel in this last line. Yeah, the plaintiffs received compensation for their personal injuries in clear liability case 3.5 years with the me see if I forget what it was.
No, and this, listen, I could give you a quick story
Oh, yeah,
about.
the record is not an impressive one, so he wasn't, the judge wasn't happy with the.
Oh, and this, I'm
No,
sure
he-
these remarks are tempered for this judge. This judge was 6'9", he was a hockey player, had been a federal judge for many years, and he was very stern at times, and he was a very imposing figure if you think about the size. I had mediation with him one time, and we went just about all day. And at one point, his client was looking to you for advice. That's what they do, and he was a good client, so he tended to follow it, and we weren't where we needed to be yet. So he says, I need to talk to you for a minute. He said, come back. So let me show you the chambers and everything back here, the new federal courthouse, all the security. We go back there, just about sticks his finger right in my chest and said, listen, you're the only person standing between an agreement and us all going home. He said, you go out there and you tell him to settle for the offer that's on the table right now. I said, just like that. You know, looking like this, and I'm not a small guy. And I said, Judge, you can't. I said, we're closer, but we're not where we need to be. I said, I'm not going to go tell him to settle for what I don't think is right. He said, well, all you got to do is tell him it's right. I said, I'm not going to do it. But I'm telling you the story so that you need to understand that that's not easy. And at that point, I had some experience. But no matter what, and some judges will, and this is the old school more so, will push and push and push you to try and clear off their own docket. But you know, especially when you're settling, you know, buyer's remorse settles in pretty quickly. And to force a deal down your client's throat that they're uncomfortable with, or to sell them on something that you don't think is right, you know, I'm going to give them my opinion, and I'm going to say, no, I don't think we're where we should be, and I think we can do better. And if he chooses to settle, that's his call, but that's his call. And honestly, if I've learned anything over time, you guys really have to be careful, because no matter what the number ends up being, they're going to talk to someone that will say, you should have got more, okay? Or you should have paid less. That's just the nature of it, or you could have done better if you talked to this or that person. And so at the end of the day, you really have to make sure that the client is comfortable with the deal, understanding the ramifications. Because if you try and force something, and then the buyer's remorse sets in, which it's going to set in, then the fact is you now have a problem to deal with, because you're probably going to get a complaint to the BPO, because everyone else did their job right. You're the one that sort of took the dive, even though you were under enormous pressure to do so.
Would I have been wrong to communicate those remarks to the judge to my client?
No, I might have conveyed it along these lines, and I might have, and I might not have. In this, telling you in all honesty, I might have said, you know, Wayne, he wants me to tell you that you should settle, but I don't think we're near. I think we're near where we need to be, but I think. And we were outside. It's an older case at this point. We were off at that point by about 100,000. It wasn't that small a case, but it was less than 7 figures. So 100 still mattered. 100 was still a fair amount to be off. Okay, and so there was still enough to fight. We weren't fighting about 3 or 5 grand. I also learned early on, if you leave a little bit, just a little bit on the table, everyone's a little bit happier. I don't have to squeeze the last buck out of you and give you a face before I go. So, you know, I'm not going to argue about 3 grand if that's what it is. By the time that's all spread out, that doesn't matter. But 100 grand on a claim that should approach 7, that's more than 10. I mean, that's a lot of money. So you can't leave that. And I probably would have told him he would like you to settle, but I would have said, I wouldn't. I think we can do better. I think you will do better. And at the end of the day, he did do better. So, I mean, but, you know, some judges don't care if you don't settle. Some judges are going to put enormous pressure on you. And this guy, he was good. He was good. I always remember the whole day. But you got to sometimes say no. Politely, respectfully, you have a different job to do than the mediator or the judge or the other lawyer. So, I know half the people in that case, and they all enlightened me at various times. What I thought was interesting about this case, too, then, if you look at the notes afterwards, I gave you should have this little order from '93. Fidelity had to pay a premium then, I think, keep this off from going on appeal, because the decision was later withdrawn at the district court level. It's something you never see. So what they did is after that decision, they settled the case and vacated the decision. And I think the insurance company paid to vacate the decision so that they wouldn't have precedent that someone could use. Because this is an unusual application of where not the insured brings the action against the insurance company, but it's the party who's been injured by the insured, because the argument is, and I think it's referenced in one of the footnotes, is that they never advance the argument that they've got no privity to make this claim. Usually the claim is only advanced by the insured, not the tortfeasor, not the injured party.
Did you find it interesting that defense counsel never brought up
Very
the fact,
odd.
yeah,
Very,
that
very.
the judge had to actually present the defense to them, that no one, I mean, that's.
It's very unusual, frankly, because these days the insurance company's attorneys, the ones they will appoint for you, are almost all captured counsel. They have their own small firms.
And they have in-house counsel as
yes.
well, don't they?
Well,
that
most of
monitor-
even the ones they appoint to represent you in these cases, while they may have a, Coin and Forbes may have a separate name. They're in the same building. They're really contracted attorneys on an annual basis by fees for the most part. So they may have a separate firm name, but they're walking a pretty fine ethical line, I think, as well. Plus the other thing is, even if it's Coin and Forbes on behalf, Allstate gives us that claim. If we keep recommending, we keep either losing cases or making Allstate pay more money than they want to, next year we won't be on the list anymore. So we're serving two masters during those cases. There's no ifs, ands, or buts about it. And that's why your role as the private attorney becomes important, because you got to keep them honest. It's not always that cut and dry. Fellheimer case from the Eastern District of Pennsylvania. Now the insurance carrier wants to settle the case, and the insured, who's been charged with sexual harassment here, and his name has been reported as such and the like. He doesn't want them to settle, even though they're settling within limits. So it's not going to cost him a dime, other than potentially his reputation. So it's another unusual insurance practices case, because most times if they're willing to pay, and it's not going to cost you anything, you say pay. And actually, for the other side, that's not that unusual, because sometimes they say, well, listen, we're going to settle a case. I don't want you to settle. I want you to try it. I've got a $5 million policy. Spend every dime of it if you have to try it. Insurance company, again, is going to look at it from a business standpoint and say, it's going to cost us $100,000 to try this case. They're willing to take $200,000. As a business matter, we're going to settle for $2,000. And we're going to wash our hands of it, because the exposure is so much more. Again, insurance companies do things for business reasons. The litigants sometimes are motivated by more personal reasons. Maybe they want vindication. But the insurance carrier isn't required to vindicate your feelings, especially if there's a situation where they feel that there's exposure and that they may have to pay a lot more than what the litigant wants to try and resolve the suit. So we've got the plaintiff's complaint. She used to work for this law firm. And then the defendant files a counterclaim against Kaplan for malicious abuse of process and civil conspiracy to maliciously abuse process. So I guess the best defense is a good offense, and you sue a lawyer and you should expect that they're not just going to walk away from it. And her complaint is that there was a hostile environment, and the insurance company wants to settle. How much they want to pay her? Did it say?
200.
Yeah, I thought it was 200 grand, right? Oh, there it is, right? So they had a discussion on May 22nd, 1995. They reached a settlement. Plaintiff executed a general release and a stipulation of dismissal in exchange for $200,000. And again, 1995. So that's pretty good money. And again, insurance companies don't pay that type of money out unless they're concerned that the liability is pretty well established. The defendant then filed an emergency motion to prevent payment of settlement, prevent the negotiations, and to stop the dismissal of the case. First of all, let me talk quickly about dismissal of cases. If you and I are litigants to a case, and we reach a settlement as they did here, and there are no insurance companies or any other parties involved, then we agree on the language of the release, you give me my money, and we file a stipulation of dismissal, which is simply an agreement under Rule 41 that you, or through your attorney, and me through my attorney, agree that the case should be dismissed with prejudice. It needs no court approval. The case is dismissed. There's a release that's already been negotiated and signed, and you get your money. If there's no answer been filed, if it's settled very early and no answer's been filed, then you can dismiss it by way of a voluntary dismissal under Rule 41. But oftentimes, once the cases have been litigated, it's going to be a release, a stipulation dismissal, and you got to make arrangements on making sure you get your checks. Here, they do that process. There is a general release. They execute the stipulation dismissal. But the defendant says, wait a minute, I don't want you to settle this. I want you to try the case. And the question then becomes, well, under what circumstances can the insurance carrier settle the case over the insured's objections? Because the insured then goes and tries to get an injunction to prevent the settlement from taking place. And they are alleging, that the insured alleges that the insurance company is acting in bad faith, not because in the last case their refusal to settle, but because in fact they're settling and affecting his rights in the process. And so there's a couple things to think about, I think, from this case. As you run your 5-part test as they did here, does he have an adequate remedy in law? Is he likely to succeed on the merits? Will he be irreparably injured? What is the harm that's affected to both sides here? And what, if any, public policy considerations are there? Why is he saying that they may be acting in bad faith here? Well, under what circumstances would they be acting in bad faith?
So the insurance company, they knew that the defendant did not want to settle without that retraction.
So he wanted a retraction and an apology.
And that they knew about it. And the insurance, and they say the insurance company didn't have authority to settle on their own.
Well, let me ask you that. Because sometimes the apology issue does come up, and the insurance says, well, I want an apology. And the other side says, well, you're not going to get one. Can the insurance, if it's just about getting an apology, does the insurance company have a right to settle the case nonetheless, if it's within policy limits and they don't leave the policyholder exposed? Yes, they do, right? Other than you don't get the apology, what rights have you lost? And that doesn't really affect their rights. What it says here is that the insurance company can't settle if they're going to leave the insured liable for an excess judgment, right? Then they have to be more careful about making sure that they defend the policy, defend the case, and not expose the plaintiff to some, or not expose their insured to additional liability. The second situation the Superior Court posited would exist, that if the harm to the insured is without regard to the fact that it may be barring a counterclaim of the insured. Well, the insured was the defendant, but as it says in this note here, or this paragraph, the insurance company was aware that he had a viable claim for damages against the plaintiff, right? If he's got a viable counterclaim, can the insured settle over their, can the insurance company settle over their insured's objection? Because if the answer to that is no, then he should get the injunction, and whether it's a wise thing or not for him to stop the settlement should be stopped. Stipulation dismissal would potentially bar his counterclaim from going forward, right?
It would, because it's not a successful prosecution.
Right?
Right.
But the counselors, they're just-
Well, but that's the problem. The stipulation of dismissal would damage his right to pursue that claim at all, because the stipulation of dismissal dismisses all claims and counterclaims by the parties. Is that irreparable injury?
That can't be settled by money damages. So, can't be cured at all.
Right? He's likely to succeed on the merits. His counterclaim can't be barred over his objection. It's an unusual situation, but under these circumstances, the insured has a right to prevent the insurance company from settling over his objections. If you just wanted the apology without the counterclaim, this case would be over. But because he has a counterclaim pending, this settlement over his objection potentially, and not potentially, it in fact is likely, to bar that counterclaim from proceeding. He may regret this decision, but he is entitled to preliminary injunction because the fact is the settlement of this matter will bar that counterclaim, and they can't settle when they are settling and creating harm to their own insured in the process. And so it may make a business sense for them to do it, but this case lives for a little longer unless he gets his apology. And that sometimes, that's a question I'll leave you with, and I've had that as well, to what extent you would tell your client to apologize even though your client doesn't think they're wrong, so you get that big fat check. Or is that just language we all have to work out about what that apology says? Well, headed apology, it says something along the line, some weaselly lawyer words that you'll all work out. No, I want him to say, I'm sorry. Says, I'm sorry, I'll pay you an additional 50 grand. Pay the client an additional 50. Amy says, yeah, tell your client to lie.
Lie, but you can say, sorry, misunderstanding, whatever.
Okay, so we'll use weaselly words, like lawyers do.
Absolutely.
I'm sorry we had to get to this point. I really am. I wish we had done it much earlier. Well, and that's the thing sometimes is, you know, and I do think there's an obligation you have with your clients. Because I can say, listen, they want you to apologize. There won't be a settlement if you don't apologize. Tell him or her, go to hell. That'll never happen. It could be the way you can help present it to. Or maybe there's language we can use that you'll live with that'll make this all work out. Sometimes people's oftentimes people's feelings have to be weighed, and it isn't a business decision, it isn't anything other than, it's not a legal decision, it's what they're thinking and feeling. And the fact is, as lawyers, we don't deal with feelings that well. We deal with money and agreements, and dotting our I's and crossing our T's. So I can work out that language, and I'll bet you can too.